Good morning, Counsel.
Good morning, Your Honors. My name is Armin Mealy. I'm here on behalf of Norwegian Cruise Line. This is an appeal from a finding by the appeals court that there was a violation, that Norwegian Cruise Line committed a violation of the Consumer Fraud Statute 93A. The trial court had found otherwise and found that there was no such violation. There are several reasons that we are asserting for why the appeals court erred in reversing the trial court. I believe the first and most apparent reason is that the 93A statute was constructed as a means to encourage settlements on 93A claims, which have been described as heavy artillery in Massachusetts state courts. A predicate of being able to bring that 93A claim is that there has to be a 93A demand letter, which states, among other things, the specific act that the target defendant was alleged to have committed.
But in this case, the target defendant didn't tell the passenger of what became the claim until maybe in response to the 93A letter, or maybe in an affidavit filed in response to your motion to, in support of your motion to dismiss. So clearly, are you saying as a matter of law there needs to be a second 93A demand letter?
Your Honor, yes, because there's no question that before this complaint was filed, plaintiff's counsel, Mr. Deacon, had in front of him all the information that ultimately formed the 93A claim that brings us here today.
You're saying he knew about that?
Unquestionably. Unquestionably.
Wait, he knew about your policy?
Unquestionably. Before the
Wasn't that
complaint was
Based
filed.
on where in the record is there any evidence that the plaintiff knew that you had a policy to assure a complete refund for anybody who disagreed with the provisions of the contract before the affidavit was submitted in response to the motion to, as part of the motion to dismiss?
In response to the 93A demand letter, Norwegian's counsel provided plaintiff with the exact same information that was subsequently contained in the affidavit that was submitted after the claim was filed.
Is the letter part of
Absolutely. I can point you right to it, Your Honor. In the letter of September 26, 2002, appearing in the appendix at page 20, Norwegian's counsel stated the following: the policy of NCL is to provide passengers with a 100% refund if they have an objection to a provision in the passenger ticket contract. Those exact words verbatim were contained in the affidavit of Jane Kilgore that was filed in connection with a motion to dismiss. So what we know now for a fact was that the plaintiff's counsel knew for 4 years that this specific act could form the basis of a claim. I completely agree, he could not have put it in his first demand letter because he didn't know.
So
but
you say as a matter of law he had a requirement to file a second demand letter?
I would argue, Your Honor, yet that in order for a defendant to be able to assess the risk of the claim that the defendant is being presented with, that defendant needs to know the act that is underlying the 93A claim, the predicate act.
Did you file a motion for reconsideration or a petition for rehearing before the appeals court?
Oh, no, Your Honor.
The appeals court says in its opinion, and I'm reading from page 77, as discussed above, Norwegian failed to do so, failed to furnish its refund policy to the Casavants prior to accepting payment. Thus its conduct violated the Attorney General's regulations. So you're saying you didn't do it at first, but you did it in time for them to write another demand letter.
We let them know before they filed the complaint what that refund policy that we were ultimately held liable for by the appeals court was. And the litigation went on for 4 full years before that claim was ever raised. And there's one point I'd really like to make clear. In addition, what's in our record here and what's before Your Honor is not simply the litigation papers, but Mr. Deacon's timesheets that delineated all the work he performed on this case. The first time that there's any mention of him doing any work with respect to the Attorney General claim was in June 5th or June 6th of 2006, despite the fact that he had the full information concerning this claim as of September 26, 2002. In response to that, oh, by the way, and that wasn't even in the first joint pretrial memorandum. We had drafts going back and forth, counsel and I. The first draft that I received did not include the Attorney General claim. The second draft, which was on Friday, June 9th, 2002, contained the claim. I said, I've never seen this claim before. And I think what's also important about this in responding to defendant's plaintiff's papers, plaintiff is right in the sense that you do not need to express every legal theory in a 93A demand in order to satisfy the jurisdictional prerequisites of the statute in order to proceed with your claim. But what you do undoubtedly have to do is advise that defendant of the specific act that is considered unfair or deceptive.
Okay, well, two things. First of all, why is your liability not governed by Section 15.04, subsection 4, which says where there is any violation of 15.04, the consumer may cancel its purchase and is entitled to refund within 30 days? Why does that not resolve this case?
Well, for several reasons.
You did not include this policy as part of the refund policy. You didn't tell anybody that you're entitled to a full refund if you disagree with any part of the contract. So that appears, you can tell me if I'm wrong, that appears to be a violation of 15.04. And the regs say if there is a violation of 15.04 and the consumer may cancel its purchase, which they did, and they're entitled to, within 30 days, to a full refund. Why does that not resolve this case by itself?
Well, for two reasons. First, the Attorney General regulation forms the basis of the 93A claim. The 93A claim requires that notice of that fact that Your Honor just mentioned, the failure to disclose a policy. 93A requires that that fact be told to the defendant so the defendant could make a decision, okay, we're at risk here because now they're asserting that we failed to disclose this policy, and now we have an opportunity to control our litigation costs by settling this claim. The fact remains is the first time that predicate act, that failure to disclose, was raised was on June 9, 2002. I offered a full refund of the ticket fare within 2 days with interest. And that,
I'm sorry, in June of 02?
2006?
2006, I'm sorry.
As soon as it was raised.
Yeah, but
Yeah.
I mean, but aren't you supposed to know of the AG regulations? You're a travel company working with business in Massachusetts. Aren't you supposed to know that there are rules governing travel policies? Isn't that what you do for a living?
Yes, Your Honor, but if there are two responses to that. The first response is if your interpretation of the statute were to be adopted, then the entire
My interpretation of the statute with regard to the demand letter or with regard to the regs? I mean, do you agree?
Oh, my interpretation.
Let's step back. With regard to the regs, do you agree that you violated or that your client violated 1504 by not giving notice to consumers of this policy with regard to a refund?
I absolutely disagree with that contention.
How? I mean,
I'll tell you exactly why. Because the trial court found that 11 months before the Casavants were scheduled to sail, that Norwegian, either through the travel agent or directly, provided them with a full cancellation policy.
they didn't. I mean, part of the policy that you didn't tell anybody about was, oh, by the way, if you disagree with the contract, we'll give you a full refund at any time. So where's that revealed?
Well, Your Honor, our argument here today, and I believe this fully, is that the refund policy that Norwegian Cruise Line advised the plaintiff of back in September of 2002, is simply an acknowledgement that they are obliged to follow the general maritime law as articulated by the United States Supreme Court. It is not a unique policy that applies to Norwegian. It is a policy that applies to all operators of...
So your theory is that you're being fair to consumers when you tell consumers if you cancel within 14 days, you get nothing back. But if you understand maritime law, you would know that if you demand your money back at any point in time after receipt of the contract, we'll give you a full refund. You don't have to tell a consumer that, even though that's part of that's what you do, it's what your policy is?
I don't think, Your Honor, that in complying with the Attorney General regulations or any other regulations that may apply to Norwegian, that it has to be specifically disclosed to consumers that Norwegian Cruise Line follows applicable law. Just like they don't have to disclose that they don't dump oil in the ocean.
Except your contract, didn't your contract say that the passage, that basically you waive all applicable law when you accept the contract with regard to various provisions, including the fact that the passage money will be fully earned at the time of payment? Isn't that what your contract said?
The passage money being fully earned at the time of payment is no different than the fact that the hotel I stayed at around the corner says that if I don't notify them in advance of canceling my room, that they have fully earned the right to accept their money because they have a room available for me that is now empty. That issue of the fully earning of the ticket fare has been litigated previously as not being a violation of any rule. It's just simply how the cruise business has to operate. Otherwise, they would not be entitled to their money until after the cruise was completed. That's just not how the business operates.
But wouldn't you say, if you say your refund policy is if you don't notify us within 14 days, you lose, or whatever that is, right?
Yeah, it's 0 to 99 days, and also, yes, it's a schedule.
Okay. So, and you say, well, the consumer is supposed to know that, of course, you follow applicable law. Well, doesn't that, in a sense, violate applicable law as you describe it?
No, Your Honor, because one of the interesting things about this particular issue is that when the Supreme Court decided the Chute case,
yes,
which is the seminal case relating to this area, there was a vigorous dissent. And in the dissent, I believe it was Justice Stevens says, does it make any sense that a passenger would ever know that they have the right to get out of this contract because they object to a provision? And the majority said that may very well be the case, but that's the way we are interpreting the law of, in that case, it was form selection clauses. They said we presume that a passenger has the right to reject a contract with impunity, which means no cancellation fees, so long as they object to that provision within a reasonable period of time. And in the context of the Chute case, that was relating to form selection clause. Now,
and do you
this is the world we operate under. There are numerous areas of maritime law that control every single operator. And I think a reasonable reading of the Attorney General regulations would require that in order to accept money from a passenger, you have to let them know what the cancellation policy is going forward with respect to a schedule. Now, the other thing that I find troubling about the appeals court decision is that if, for example, Norwegian Cruise Lines was required to tell every single plaintiff or every single passenger, oh, by the way, if you review our contract and you object to a provision and you don't agree to those terms, we'll give you your money back. It is an undeniable invitation to a pretextual reason to get out of the cancellation fees. The cancellation fees then become irrelevant.
So you don't have to have a good faith basis for objecting to a term in the contract.
Oh, no.
You just
If you say, I don't accept this contract, then under the general maritime law as articulated by Carnival v. Chute, you get your money back.
But you can't have it both ways. You can't say that our foreign selection clause is okay because you have a right to reject with impunity, and then conceal the right to reject with impunity.
Well, see,
Because you don't want to live with the consequences of it.
well, there's another aspect I think that would be important for us to address here. Even, let's presume, arguendo, that there is a per se violation of the Attorney General rules here. There must be causation even on a per se claim. That's articulated in Hirschenau. The trial court found specifically, after hearing the evidence, that the plaintiff did not read the contract when he got it, never reviewed it before he made the decision not to sell, and in fact did not reject a provision in the contract because all he wanted to do was reschedule.
But what difference does it make? If Section 1504 was violated,
Yes.
isn't that the end of the story?
No, because it is not. In order to have this presumption of causation, the non-disclosure has to be material. And in a case where you had a plaintiff testify at trial that I did not review the contract, nothing in the contract informed my decision as to how I wanted to proceed with respect to this cruise. I wanted to reschedule the cruise to a time when I could have been assured that things would be safer after 9/11.
Yeah, but under Section 1504, the failure to provide, to fully disclose the contract terms or this cancellation policy, in and of itself entitles the plaintiff to get their money back.
Yes, and when
That's the,
and when that claim was raised to me for the first time on June 9, 2006, on June 12, 2006, I made an offer of a full refund of the ticket fare. Now, that doesn't mean, and I just want to be very clear, that doesn't mean that I'm conceding that we violated the statute. But what it does mean is that in a risk assessment situation, I was confronted with a claim. 2 days later, I said, here's your ticket fare. I had no opportunity to do that before June 9th because it was not in the case.
I have a question. On page 21 of your brief, you say that, in addition, Casavant does not explain why it did not send a second demand letter detailing the claim under the AG regulation after it was admittedly aware of NCL's disputed refund practice. When did they admit they were aware of your disputed refund practice before that affidavit?
Because in the complaint, as a jurisdictional prerequisite to file a 93A complaint, the plaintiff stated two things. The plaintiff stated, I served the 93A letter and I got a response. And in that response, I was not offered a settlement. That it is undisputed that the plaintiff's counsel had in his possession the letter informing him of the refund policy before the complaint was filed. It was faxed to his office on September 26, 2002. The lawsuit was not filed, I believe, until October 3, 2002. And there's never been a suggestion in this case at any time that there was no receipt of the demand letter, of the response to the demand letter, and that there was any misunderstanding as to what the response to that demand letter said, because it said exactly the same words that Jane Kilgore said in her affidavit down the road when we made our motion.
Yeah, I'm reading it. I'm sorry. Where are those words? I'm looking at I've read your letter. Tell me which words you say.
The demand letter?
No, the response to the demand letter.
Okay,
Which you
Your Honor,
say-
hang on.
I've got it in front of me. I read it earlier.
I believe it's on in the appendix.
No, it's Plaintiff's Exhibit 10.
Page 21.
This is the letter, dear Mr. Deacon, from Peter Young, correct?
Yes, Your Honor. It's on page 21 in the appendix, second line down. The policy of NCL is to provide passengers with a 100% refund if they have an objection to a provision in the passenger ticket contract.
I'm sorry, this is on...
Page 21. And if Your Honor, if I may, while you're looking at that, I just want to point one other thing out. At the time...
Hold on for a second.
Page 21 of the appendix?
Volume 1 of the appendix?
Volume 1 of the appendix, page 21, September 26, 2002.
Two different letters?
We got two different letters here? No, it's the same.
Second and third line?
Okay. And I'm sorry, and where is this?
It's the second sentence in the paragraph at the top of the page, the second and third line.
I still.
Your Honor, may I provide you with my
I mean, I've got it in front of me. I'm just trying to find out what you're talking about. Which paragraph is this?
It's at the top of the page, the second line down. It is.
Are you on the first page of the letter?
No, I'm sorry. I'm on the second page of the letter. I was asked where in the letter.
Oh, okay. I'm sorry.
Just one point I'd like to leave you with before I sit down. At the time that this specific act that we allegedly performed that underlies this 93A claim, plaintiff had conditioned settlement on 90 hours of legal time, not 1 minute of which was devoted to any claim relating to this, any work relating to this AG claim. Not one, because in the appendix to our brief is his legal time, his detailed timesheets. First, the notion of this concept was first entered the plaintiff's counsel's mind on June 6, 2002, and yet the condition to settle this claim was now 100 hours of legal time that preceded it. And I just don't think that is what the statute is meant to accomplish. Thank you.
May it please the Court, John Deacon, representing the Casavants.
Mr. Deacon, the only thing at issue right now is attorney's fees, correct?
Yes, Your Honor.
That's all we're fighting about.
These people had
Yes.
their refund years ago.
They had it after the trial, after judgment was entered.
No, there was an offer of a refund back in '06.
That's not correct. He
He
offered
just said he offered a refund on June something or other '06.
to refund the ticket price, which was the $2,000.
Right.
He did not offer interest. He did not offer costs, which at that point, that was after the appeal to the appeals court, which the plaintiffs won, and he conditioned it on dismissal of the 93A claim. So the settlement offer was principal only, and interest was 3 or 4 years at that point, and the cost, the taxable costs were nearly $1,000 from the first appeal. And, Your Honor, the settlement offer, the argument about the settlement demand is a red herring for several reasons. First of all, they made this argument to the trial court. It was rejected, and they did not appeal from the trial court decision.
Which argument?
The Superior Court.
No, I understand that, but when you say the settlement demand, I'm sorry, which argument?
No, I'm sorry, Your Honor. Their argument about the inadequacy of the plaintiff's pre-litigation demand letter under 93A.
Didn't the trial court say that you had notice as of September 26, 2002?
The defendant's response letter did say, by their attorney, did allege that Norwegian had a policy.
Isn't that part of, was it Judge Henry? I forget.
Yes.
Wasn't that part of his decision?
He never found that the plaintiff's demand letter was inadequate or insufficient. The trial court's decision on the 93A claim was based on a speculation about lack of causation.
Speculation or finding?
It was speculation, Your Honor.
Well, I thought your clients testified that they didn't have any objection to the terms of the contract, and that was really not what they were complaining about.
In a case of unlawful nondisclosure, the issue that the trial court was speculating about was what would the Casavants have done had Norwegian complied with its legal obligation and disclosed this purported refund policy. Would the Casavants then
I thought they
have
testified.
invoked-
I thought they testified that that was not their issue was concern about terrorism after 9/11, and it wasn't an objection to anything in the contract.
They did not testify about what happened when Norwegian disclosed the refund policy, because Norwegian never disclosed the refund policy. If Norwegian had said to the Casavants, we have a refund policy.
Then they would have said we have a problem with the contract.
We don't know what they would have said because it's not a historical event. It's not something that happened
But they
in
test.
time.
All right. I mean, so their testimony on this subject is not to be given any weight at all? That they didn't have a problem with the contract? That wasn't their concern? That's not why they canceled?
No, Your Honor.
So we
It's
give that
not
no
to
weight?
It's not to be given any weight. There's a rule of law which we've discussed at length and which was discussed by the appeals court and which is the essence of this case, that in a situation involving an unlawful nondisclosure of material facts, if the facts are material, then there's essentially a presumption that the plaintiffs would have relied on the material disclosed, and causation is thereby proven. In this case, excuse me, Your Honor.
Well, I guess the trial's in whenever it was, 2000, when was the trial?
I believe it was fall of 2000.
Okay, fall of 2007. So I understand nondisclosure, and of course, at the time that they said they wanted their money back, I mean that they wanted to reschedule, they didn't know about this. Okay. But at the time they're testifying at trial, they obviously knew all this stuff. And so there was no testimony, though, that, gee, if I'd known about the contract, I would have done X, Y, or Z. Is that true?
That was a judgment that I made, Your Honor. I conceive of the testimony they're giving about is dealing with the historical events, about what happened at the time, what they knew at the time, asking someone, well, if something happened that didn't happen but was legally required to happen, what would you have done then? To me, that's not testimony based on personal knowledge.
But
that's speculation.
Did you say earlier that there was the non-occurrence of something that was supposed to occur, in this case the disclosure, does it create a presumption, did you say, that the people would have exercised the rights that would have been provided had disclosure been timely?
I don't think the cases refer to it as a presumption. I think it's a rule of law. I don't think it's a presumption that is rebuttable. There's no language in any case that I've seen on this issue that discusses rebutting this rule.
So
I
I think you said the unlawful nondisclosure of material facts is per se injury.
That yes,
essentially it?
that proves causation.
Proves causation.
Yes.
Oh, okay.
And I think in this case, the subject facts being this refund policy that they allegedly had, that is necessarily material because the Attorney General, in writing a regulation that required disclosure of that type of information, made a decision that it was material.
Well, so long as the attorneys, excuse me, go ahead.
Mr. Deacon, the trial judge said, and I quote, the Casavants had no objection to the terms of the passenger ticket contract. They simply did not feel comfortable taking a cruise at that time, end quote. Now, are you saying that the judge was clearly erroneous in those two findings?
No, Your Honor. What I'm saying is
doesn't that resolve it then?
No. The Casavants, like probably virtually every other passenger, did not read the passenger ticket contract of passage. It's 28 paragraphs of fine print. It's difficult reading even for a lawyer with expertise in maritime law. The fact of the matter is passengers don't read these things.
And the judge said they simply did not feel comfortable taking a cruise at that time. Doesn't that resolve it? Doesn't that tell us that they had no objection to the contract, that they just didn't want to go at that time?
No, Your Honor. What was key here was the legal requirement that Norwegian, as a seller of travel services, disclose such a refund policy.
You just conceded that they, which I'm sure is true, they never read all the fine print in the contract they were given. So if they had been given another page which complied with the condition that, with the requirement that they give 100% refund, they wouldn't have read that either.
Oh, I don't, well,
You just said they didn't read it, so if they didn't read what they got, if they got even more, they weren't going to read even more.
well, notwithstanding that they didn't read it, Your Honor, what they did do was request a refund. One of the terms of the passenger ticket contract of passage is that the money paid is fully earned upon payment with no right to refund under any circumstances. They requested a refund, therefore they objected to that provision. They also
Oh, go ahead.
They also objected, to pick another example, one of the terms of the contract of passage is the forum selection clause. They objected to Dade County, Florida as a forum, and they litigated that objection through the Court of Appeals.
Did you, when you said that
won.
they requested a refund, so that, back in 2001, so there was alternatives, we would like to reschedule, but failing that, we would like a refund? Is that-
Yes, Your Honor, and that's not disputed. They had 3 conversations with Norwegian, telephone conversations, and then they had a letter, so 4 communications, and then follow-up communications during the course of the ensuing year. They initially requested rescheduling. Norwegian's response was, you have to cancel your voyage. When they couldn't work out rescheduling, they asked for a refund.
Can you help me out with the nondisclosure? I'm following you. I'm not necessarily saying I agree with you, but I understand what you're saying about nondisclosure of the cancellation policy is itself actionable. I mean, that is the it proves the causation. Okay, so let's say they took the trip, and they, at the end of the trip, they come back, they find out that there's a nondisclosure policy. They want their money back. Are they entitled to get?
Well, they haven't suffered a loss in that case. There's no damage.
That's Hirschenau. Isn't that Hirschenau, pretty much exactly?
I don't think so, Your Honor. I think in this hypothetical, their cash payment was converted into the value of taking the trip. They haven't suffered a loss.
Well, I'm saying
Here-
that. I mean, Hirschenau, they had the rental car. It wasn't after they used it and they returned it that they saw that there was a problem.
Well, yes. But I think the Hirschenau and the hypothetical by Justice Spina go to not causation of a loss that's incurred, but the lack of any loss at all.
Okay, so I'm getting back to this concept of a presumption. You say that nondisclosure proves causation, yet there are some circumstances where there is no harm.
No, Your Honor. Here there was undisputably a loss. There was damage. The Casavants paid their ticket price, and it was never converted into the value of taking the voyage. They didn't get value for what they paid. So they're out $2,000. That's undisputed.
So essentially, you're saying if the Attorney General has, through their regulations, required that something be disclosed in consumer agreements, rental agreements, whatever, and it's not disclosed, and there is harm, even though the harm has nothing to do with the information that was to be disclosed, that the failure to disclose is the cause of the harm. Yes?
Well, I'm talking about the Attorney General's regulation that applies in this case, Your Honor, and specifically states
So you said if the
that
Attorney General says that you have to disclose it, then it's material. If it's material, then it's causation to any harm that results from the contract. That's what you
Yes.
just said.
Yes.
And if the boat's out in the middle of the ocean on the second day of the cruise and it runs out of gas or something happens, as recently appeared in the news, they couldn't bring an action because of failure to disclose.
Well, that's not this case, Your Honor.
Yeah. I'm just trying to figure out what nondisclosure, how far it really goes, what it really means.
Norwegian's a seller of travel services. If they want to do business in Massachusetts, which they do, they should have read the law that governs sellers of travel services, which includes the Attorney General's regulations. They're not that complicated, and disclosing a refund policy is not an onerous requirement. disclosing a refund policy before accepting payments from a passenger is not a difficult thing to do, and it's something that
But 93A also is a requirement too. You've got to give notice as to what's the violation, what's the unfair practice. And you knew about this on September 26, 2002, and you didn't give notice until 4 years later, just before the trial.
I wrote the demand letter based on what was known at the time, Your Honor, after the...
And very shortly thereafter, this was disclosed, that this was their policy. You knew that it was not a policy that had been disclosed. The regulations are easy. You knew now that's a violation of the Attorney General's regulations, but that never got, there was no demand ever made on that until 4 years later.
In York versus Sullivan, Your Honor, this court held that a plaintiff's 93A demand letter is not required to include facts which the defendant unlawfully failed to disclose. What it doesn't say is that when the plaintiff eventually finds out about the defendant's unlawful nondisclosure, that another 93A demand letter has to be sent. There's no case that holds that.
So once you've made a 93A demand, even though what's in your demand has nothing to do with what ultimately gets and you filed your complaint, even though it has got nothing to do with what ultimately gets litigated, because you made a 93A demand letter, you're good. It doesn't have to include what it is that you...
Defendant have an opportunity to settle the case if he doesn't know what your claims are, on what your claims are based.
They did have the opportunity to settle the case, Your Honor. I set out the entire factual history of the relationship and asked for a refund. The primary basis of the demand letter was the Casavants had never accepted the contract. That was basic. That was obvious. Norwegian took a totally baseless legal position that the Casavants, by remaining silent, had thereby accepted the contract. And they didn't remain silent. The first words out of their mouth after receiving the passenger ticket contract of passage on September 11 were, we don't want to take this voyage.
Thank you, counsel.
Thank you, Your Honor.